I wanted to just go over a little bit of a timeline of where we are. As we know, this particular disparity study is to be completed every 5 years. The 2014 study was delayed in 2009 and again in 2012. The council, actually this committee, and then with approval of the council, we did include $600,000 for the study in the FY13 operating budget. It was finalized on June 11, 2014, and the county executive transmitted the study to the council on July 1st, 2014. We then appointed, this was a proposal of the committee to the council, and it was adopted to appoint 2 task forces that were created on October 28th, 2014, and appointed on January 20th, 2015. One of those task forces was to look specifically on issues of procurement for the minority female disabled owned businesses. There was also a Bill 48-14, which was introduced on October 21st, 2014, and enacted on April 14, 2015, that was introduced and sponsored by Councilmember Rice, who is joining us today. Also the task forces transmitted their report to the council on September 15, 2015, and then both task forces were able to brief the committee on the final reports on October 13, 2015. Bill 48-14, which was purchases from minority-owned businesses procedures, requests for proposals, was approved by the council on April 14, 2015, and this permits the Office of Procurement to establish an evaluation factor in a request for proposals that awards additional points for a proposal from a contractor from whom a goal has been set up under the MFD program, and a contractor from whom a goal has not been set, who proposes to exceed the minority-owned business procurement subcontracting goal established for the contract. The preference can be up to 10% of total points, and the Director of Procurement has the discretion to use it in appropriate circumstances. Of course, our council staff did caution that the preference cannot be, quote, so great to make it almost impossible to win the contract as a non-MFD firm, end quote, and it was believed that a 15 to 20% preference as originally introduced may be too much for legal muster. You know, one of the reasons why I felt it was important to establish the task forces, and so many of you who are here today who spent so much time chiming in, is because in the past we would have to report and then that was it, and then there were maybe some things that would be considered, but we never really completed the loop and then turning it over to the practitioners and those who are running the businesses to give us feedback and to give us possible recommendations that we could definitely enact. And so we have had one session, as you know, to go over the breadth of the recommendations. We said we would come back and take a look at which are those recommendations that we should dispose of that might require just some administrative type of approaches, et cetera, and those that may require a little bit more study, because I will say that even though this council has never shied away from pushing the envelope, we also have to be mindful of whether pushing the envelope means that we might inadvertently do away with the entire program if indeed there would be a legal challenge. And that, in my opinion, is a big responsibility that I take very, very strongly, because I would not want to be the kind of legislator that in an attempt to really push the envelope ends up with an entire sort of elimination of a very important program that no doubt needs to be strengthened. And so that, I think, is going to require a little bit more conversation, a little bit more analysis, but there's no doubt that there are quite a number of recommendations in the task force report that I think that we should immediately act upon. And then take our time to make sure that we're dotting all the I's and crossing all the T's when it comes to those other more aggressive and unprecedented type of approaches. And so I'll definitely, we will all continue to work together on all of this.